application is a matter of British Telecommunications PLC and the Queen and Commissioners for His Majesty's Revenue and Customs. Part heard.
Yes, good morning, Ms. Mitchell-Farnes.
Morning, my lord. Just one short point on timetabling.
Yes.
I'm feeling a little short of time. My learned friend is feeling a little short of time. So what we've agreed is that we may take up a little more time with issue 1, but we've said we will be done with issue 1 by 1 o'clock today, rather than the original 12:15. And I've also agreed that my learned friend can have 45 minutes in reply on issue 1, rather than the 30 minutes originally allocated.
So you'll finish at 12:15?
That's right.
Is
It
that
may be sooner, but that's we've shaved off your issues 2 and 3.
is that going to give you enough time? I mean, we appreciate these are significant issues for both parties. One of the Constitution does have a difficulty on Friday afternoon, but we might be able to go a little bit beyond 2 o'clock on Friday, but certainly not all day. So should we leave it at that for the moment and see where we are?
Yes, just to explain before I launch in, on the basis that I wouldn't have very much time, I've set out some points.
Yes.
In shorter form. Perhaps then, if we do end up going over the lunch point, if there's anything further that I can expand on, I'll do it that way rather than try and rejig things now.
Yes. Okay.
So, I set out the statutory appeal position yesterday, and now I'm focusing on issue 1, the exclusivity issue.
Yes.
And first, I'll set out our position on why we say the old scheme is clearly exclusive. And then, in the second part of my submissions, I'll respond to my learned friend's main objections to that position. Now, there's a summary of the right approach on exclusivity in the case of Southern Gas, and that's set out fully at paragraph 67 of the judgment below. Again, if I can summarise the principles there, rather than go through it paragraph by paragraph.
Is this Lord Justice Higginbottom?
Yeah, that's right.
And by exclusivity, you mean exactly the same as ouster?
Yes.
There's no distinction between them in your submission?
There is no distinction. The reason exclusivity is preferable is because ouster has the sense of getting rid of a particular remedy. The point is it's exclusive. If you want to
it's more difficult
it's
more difficult to say Parliament intended to oust the mistake of law remedy when at the time no one knew the mistake of law remedy existed.
Well, and that's why the
but it's easy.
Ouster is inappropriate, but it's been made clear in ITC in the Supreme Court that that's not a good point, as it were.
Yes.
An implied ouster, or an express ouster for that matter.
No, but as a matter of language,
Yes.
you're more comfortable with saying this was intended by Parliament to be an exclusive remedy, which leads to the consequence, if you're right, that all other remedies are ousted, including ones you don't know about.
Absolutely.
Than using the language of saying Parliament intended to oust something, which is just sounds less comfortable.
Absolutely.
When it didn't know it existed.
Yes. So exclusive. Parliament enacted this and meant this is how you do it, and only this.
Yes. This is your remedy for this.
Yes.
Yes.
So to summarise the fundamental principles set out by Lord Justice Higginbottom, exclusivity depends on whether, on the true construction of the provision, Parliament intended it to coexist with a common law remedy. For implied ousters, the test is not whether, as a matter of logic, the ouster has to be a necessary implication. It all depends on the particular provision's construction. But where the statute and the common law cover the same ground, the common law remedy will almost certainly have been excluded. If the statutory regime is special or qualified, it may be inferred that Parliament intended to exclude any common law remedy arising on the same facts, but some differences will not necessarily lead to that inference. They should be substantial. The question is whether, looked at as a whole, the two would be incompatible. And we say first, the old scheme was specifically enacted to implement Article 11C1 of the directive. That's not in dispute. The UK didn't just come up with a scheme for seeking refunds in cases of bad debt. it of course enacted the old scheme specifically to implement Article 11C1.
That is what, as a matter, because that's what previous judges have said, or because it's obvious, or?
Both. Upper Tribunal, I think it was around...
Yes.
I made the point yesterday, but the Upper Tribunal said purpose of the bad debt relief scheme was to give effect to Article 11C1, but also it's obvious. As I said, Parliament didn't just wake up one day and think, what should we do about bad debts? It was trying to implement 11C1, which required it to come up with a scheme subject to Member States' conditions.
And there was no previous provision before 78?
Nothing at all.
No.
I'll come back to this. But not only was there no domestic provision before 78, but there was no EU requirement before 1978.
Yes, we were told that yesterday. The second directive didn't have any similar provision.
Yes, and that's important for a point I'll come on to in issue 2.
And unlike some of the other member states, the UK before accession never had a turnover tax of this type at all. Is that right?
Before 73?
Yes.
I don't think so.
No, absolutely not. Just purchase tax.
Yeah.
Yes. Purchase tax.
Yeah. So, I mean, the point being that for the UK, VAT was an entirely European thing. It came from Brussels and was implemented because of joining the EU. It wasn't something we had and were using anyway, or had a domestic tradition of.
No, not at all. And the requirement to implement Article 11C1 kicked in under Article 1 of the Sixth Directive, January 78, and that's why the UK was 9 months late when it enacted the first old scheme in October 78. So, first 9 month claim period, no scheme at all. And certainly none before 78. And then old scheme comes in October 78. And we say that the fact that the old scheme had the purpose of implementing Article 11C1 is relevant because, of course, it supports the view that in enacting a scheme to give effect to Article 11C1 rights, Parliament gave specific consideration to the shape that such relief would take. And it's particularly important in this case because Article 11C1 itself states that the taxable amount is reduced under conditions which will be determined by the member state. Of course, the old scheme does just that. It makes relief dependent on an optional claim to relief under the scheme. That condition has never been criticised by my learned friend in the many rounds of hearings we've had. And we saw in BTCA and GMAC that the scheme itself was not objectionable. The only objection was the insolvency condition.
Has the CJEU pronounced on what the scope of the member states' discretion to impose conditions is?
There is case law on that. About procedural conditions and substantive conditions, and obviously substantive conditions mustn't be disproportionate, and that's why we don't have the insolvency condition. But as I say, it's never been said that the procedural requirement, it's not a requirement, the option to make a claim has never been criticised. I think the only time that the UK regime itself went up to the CJEU was in the Goldsmith case in 1994.
And that was specific to the barter point, wasn't it?
Absolutely. So it wasn't an issue, but again, there was no criticism of the old scheme as such. And I think it's paragraph 126 of GMAC that I went to yesterday, where the Court of Appeal sets out the scheme would remain intact once you get rid of the insolvency condition. So it's not, I say, open to my learned friend to now say, oh, but there's something wrong with the requirement to make a claim itself.
Well, anyway, I didn't understand him to say that.
No, and he never has, I think.
Yeah.
And of course, we know from BTCA that if no claim is made in time, as was the case for BT, there's no reduction in the taxable amount. So Parliament couldn't have intended that the old scheme be ignored and that a trader instead argues that it overpaid VAT, that the taxable amount had been reduced even though it hadn't made a claim under the old scheme. Now, one point my learned friend makes repeatedly in his skeleton argument is, well, Parliament didn't enact any scheme for the other aspects of 11C1. For price reduction, it took another 10 years and so on, perhaps didn't at all for some other aspects. And he said, and it said in the skeleton, that that's an indication that Parliament was very comfortable leaving these circumstances to the common law. And we say that, in fact, this is our case. Parliament looked at 11C1, did nothing about price reductions for another decade or whatever it was. But in the case of bad debts, non-payments, it did act. So
there were five, we were told, 5 circumstances under 11C1, 2 of which are covered by bad debts, total or partial non-payment.
And then there's
The other 3 are cancellation, refusal and reduction in price. What do you say the position is with those?
Well, with respect, I don't need to
You don't
explain
need
it
to.
in the sense that...
It doesn't, you say
I
it
don't
doesn't
think it's
matter.
I don't think it's controversial between us, but the point that's being made against us here is, well, Parliament either acted late or didn't act at all in relation to other aspects of 11C1.
When did Regulation 38 come in?
Regulation 38 came in its original form in 1989.
So it's really
Section
quite
34.
really quite late.
Yes.
21 years late.
Yes,
Yes.
but that, and this is the point I'm making. If Parliament didn't act at all for certain gateways, as my learned friend calls them in 11C1, certain words, certain circumstances in 11C1, or in the case of price reductions, waited until 1989 to bring in regulations, that tells us that Parliament was comfortable with leaving those aspects to the common law. It doesn't help my learned friend, because when Parliament looked at partial or total non-payment, Parliament decided to act. In other words, unlike in those other situations, we're not going to leave it to the common law, we're going to introduce a scheme. So as I say, that assists our position. Parliament made a conscious decision for bad debts that it would act, and that it specified through the Section 12 and the regulations that accompanied it how bad debt relief would be claimed.
I'm assuming there's no evidence as to the parliamentary materials. We don't have white papers or departmental explanatory notes or anything like that.
It's
purely
construction.
Yes, purely based on the words of the statutory material.
But as I say, if Parliament had intended that bad debt relief be left to the common law, why did it come up with the old scheme? Why didn't it do what it did for price reductions and do nothing for 10 years?
Yep.
That's the point I'm making. So it assists us that Parliament acted in relation to BDR and didn't act in relation to other aspects, or didn't act in relation to other aspects until later. And the next point I rely on is that the old scheme covered the same ground as a common law remedy. That has to be right on any view. The old scheme remedy and the putative common law remedy are founded on the 11C1 right that when a supplier accounts to HMRC for tax, but then doesn't get that tax from its customer, that it reduces the taxable amount, i.e. doesn't account for the tax that it didn't receive from its customer. And we say that's important because it was said to be a clear indicator of exclusivity in the CPAG case in the Supreme Court.
Do I take it that in your session there's no distinction between exclusivity in the tax field and exclusivity in other fields? Because both CPAC and Southern Gas and indeed Mark Church have got nothing to do with tax, but are the principles the same?
Yes. I haven't seen anything that suggests they're not, and I think in CPAG itself it's tax cases are discussed.
Total networks and so on.
Yes. And I don't think my learned friend says that it's different in the tax arena.
I will be.
I thought there was a suggestion floating around somewhere, it's probably come from Mr. Cordara, that it's different with tax.
I can answer that if somebody reminds me in one sentence why it said it's different.
Mr. Cordara, do you want to?
Well, I tipped my lane friend off overnight. But what I would like to say, the AutoLogic case, which the Crown produced yesterday, we say is the place to look for the right approach in a tax case. And there was exclusivity, but also an afterlife for claims which either had to be pushed through the exclusive direct tax machinery of the special commissioners. But if those claims turned out to be time barred, then the majority in the House of Lords held those will have to proceed by common law means. And just to add one quick point, the difference between the majority and the minority is that the minority thought that they should all proceed by common law means, that the majority said no, that's not a tidy way of doing things. So I say that's going to be the right approach.
So the first point to note in what my learned friend just said is that it's a new point. So it's not a point that was made yesterday. As I'll come on to explain, what's happened is that I put in the AutoLogic authority into the blue additional authorities to deal with a point in issue 2. My learned friend informed me at 8 AM this morning that although he's finished his submissions on issue 1, that he'd like to rely on AutoLogic for a point. And I will come at the end of my submissions to answer what my learned friend has just said. But yes, in answer to my Lord's previous question, no, it wasn't my learned friend's position yesterday because, as we've just heard, the position that tax is different depends on AutoLogic.
Yes.
And it's a point that wasn't made in my learned friend's submission. So, a little conscious of time, I'll just outline the CPAG position. It was considered there that the statutory provisions and the common law position covered the same ground, even though the statutory provision related only to recovery by the Secretary of State of benefits payments where they'd been made on the basis of misrepresentation or a failure to disclose. The statutory provision said nothing about the position where the Secretary of State had made an official error and sought to pursue a claim at common law. The Supreme Court nonetheless considered that the provision was exclusive. It meant that there would be no claim in case of an official error at all. And again, because I'm rushing it a little bit, for your note, I rely on paragraph 14, where Lord Brown emphasises the importance of Parliament setting up a scheme and providing for the whole process of determining the facts relevant to entitlement, and also making provision for appeals to the tribunal, which is our case. The old scheme set out an appeal procedure and jurisdiction for the tribunal. That's paragraph 14, which you'll note is at page 853.
Is that the Administrative Appeals Chamber of the First Tier Tribunal?
Forgive me, my lord.
Was it the Administrative Appeals Chamber of the First Tier Tribunal?
For
in CPEG.
I think it was, man. But it was a specified statutory tribunal, it wasn't common law.
Yes.
And we have here the jurisdiction of the first tier tribunal set out in section 12, section 22, new scheme, it's always been...
the point about tribunals is they often have a specialist jurisdiction and a specialised knowledge of a particular area.
Did my lord say the problem with the tribunal?
No, the point about them.
Yes, precisely.
Yes.
And that's also proved in the second leading judgment by Sir John Dyson. For your note, it's paragraphs 31 to 35, which also make the point that if two remedies cover the same ground, and if the two remedies cover the same ground that are inconsistent, the common law remedy will almost certainly be excluded. And we say that in our case, the two would be inconsistent. As I've said, under the old scheme, relief depends on a claim being made, and the regulations explain how exactly the claim is to be made and so on. What records are to be kept, which tie in with the timing of the claim, and presumably allow HMRC to inspect the claim for bad debt relief and so on. And I'll come on to the regulations in a moment. And of course, we also have the substantial condition of the insolvency condition. Now, it's true that the insolvency condition has been held to be unlawful, but we say the right approach is as follows. Determining exclusivity is primarily an exercise in statutory construction, trying to identify what Parliament was trying to do. And the only plausible explanation for Parliament having the insolvency condition is that Parliament was seeking to control and limit access to relief. Could not have intended that the old scheme be ignored, the insolvency condition be ignored, and the common law remedy be pursued. And so, as was said below, in my submission, the insolvency condition should not be ignored when asking the exclusivity question, and I found no authority that suggests it should. Rather, the correct approach in my submission is that the unlawfulness of the insolvency condition is considered at a sort of next stage of the inquiry, sort of prima facie exclusivity, but are we really going to find exclusivity here? And at that next stage, one has to ask, if the old scheme was exclusive, would it be EU law compliant? And we know that properly construed, the old scheme was EU law compliant because you can just get rid of the insolvency condition. So
that's a very odd use of the word compliant. You have a scheme which is non-compliant because it requires insolvency, and you say, because it's non-compliant, and as a matter of EU law, the insolvency condition is to be treated as disapplied, therefore it's compliant. That does seem to me to be a bit of a bootstraps argument.
well, the position is, what is Parliament trying to do when enacting the old scheme? On its face, it's clear that, it's clear that it intended it to be exclusive because it's got various conditions, claim condition, the insolvency condition, and we'll see the procedural regulations as well. That's not the final answer, because one must also have the EU considerations in mind. Can it really be right to imply exclusivity here? And that's the EU law question. And when one comes to do that, it depends on whether it can properly be construed to be EU law compliant, because that's what leasing is. It's the court saying, on its correct interpretation, the old scheme can be made compliant. And that's
you say leasing and you say construed. Some of the judgments draw a distinction between construction and this application. It's quite difficult to construe a requirement that somebody be insolvent as meaning the complete opposite.
Perhaps then I'll just use the word that BTCA used, which was moulded.
Moulded,
It can
yes.
properly be moulded to ignore the insolvency condition. And remember, it's not that I think the reason I'm getting a raised eyebrow is because that seems a little bit odd. But remember, that's what BTCA said. Your EU law rights have been given effective protection because of the proper interpretation of the old scheme, i.e. without the insolvency condition. You had every ability to come to seek a remedy under the old scheme. You simply didn't do what lots of other traders do, which is go to court and say, I think the insolvency conditions should be moulded away.
Well, you say lots of other traders. Apart from GMAC, we haven't been shown.
No, sorry. I didn't mean in this particular old scheme provision. I meant generally.
People take EU points, you mean?
Absolutely, and that's what the BTCA meant when it said EU law's been flowing forward from since 1972. Ignorance of the law is no excuse. You've had every opportunity, and so on. Paragraph 119 to 123 of BTCA.
Just as an aside, do you understand how you mould the regulations to get rid of the insolvency condition? Because the insolvency condition is doing something. It's proving that somebody can't pay, that the debt really is a bad debt. What do you put in its place to establish that there's a bad debt?
Without the insolvency condition.
Without the insolvency condition. How do BT satisfy the commissioners, if they'd done it in time, that somebody who didn't pay a telephone bill was a bad debt?
Presumably through evidence. So if BT had done what it eventually did, but in time, it would have said, court, please mould away the insolvency condition and provide me with bad debt relief. The court would have to find some way to give effect to that. So it would say, when was payment due from your customer? What chasing letters did you send? How long's it been? And it would make some decision. Importantly, again, not for this court, because BTCA has decided.
But there wasn't any
the scheme was properly interpreted.
Yes, no, I understand that entirely. That's why I said it's an aside, because
Sorry.
it doesn't seem to me to be decisive of anything. But I just wondered, as a matter of practice, did BTCA give any indication of how it should be moulded? Because there is you would have thought, a theoretical difficulty with saying, here's a bad debt relief scheme. All you have to show is what? That it's a bad debt, but there's no statutory definition of when a debt turns bad. It's not like a contract being cancelled when there's an event, in which case your consideration ceases to be due. If somebody just doesn't pay their phone bill, the money's still due, it just hasn't been paid. Well, it's not paid on day 1, it's not paid on day 20. When does it become a bad debt? And the point of the insolvency condition was to give you an event which said, from now on, it's a bad debt. And you get rid of that, it seems very uncertain, which is...
And what we have in the new scheme is time periods. You can't
Yes.
enter before 6 months. It used to be 2 years and now it's 6 months.
But when you say moulding, what? You can't change the language. You can't find in the language of the old regulations anything which tells you what a bad debt is other than the insolvency condition.
No.
So if you get rid of that, the court just has to make up its own.
But you have to read in the directly effective rights, don't you? I think that's the approach taken in, I'm not sure in this case, but in some other cases. So it then becomes a question of evidence as to whether there really is a bad debt within whatever the directive might be taken to mean in that respect.
And also, I'm grateful, and also the way it's actually done is you strike out the insolvency condition from section 12, and then you go through the regulations, and if there's anything that relates to the insolvency condition, you get rid of that. But you're still left with a scheme, because the trader, when it considers the debt to be bad, will make a claim. It will keep records, I'll come on to this in the regulations, it will keep records showing that it invoiced, that it made the supply, that it paid the tax to HMRC. There's a provision dealing with what's the outstanding amount, and there's also a provision dealing with if you haven't kept those records, HMRC will ask you to repay any bad debt you get.
Thank you.
So any bad debt relief you get. And my learned friend's answer to the submission I made regarding it doesn't matter that you've got to mould away the insolvency condition, that's not an obstacle to exclusivity, is the FII 2012 case. Because there, when the Supreme Court was grappling with this issue, I won't ask the court to turn it up, but remember it's 116 to 119, it's in our skeleton, Lord Walker, in paragraph 204 to 205, the assumption. But in both those judgments, what's going on is the court is saying, it's trying to do what BTCA and this court have to do together, doing it in one go. We have BTCA saying you can mould, and this court is going to decide if it's exclusive. But in FI 2012, the court was trying to do the two at once. And it was saying, well, is it exclusive, or is it better to interpret it as better to interpret it as non-exclusive? And it asked the question, well, in order for it to be exclusive, to give effect to directly effective EU law rights, we'd have to mould it. We'd have to apply more leasing. And both the lordships considered that that couldn't be done in that case. Court will recall that Lord Walker said it would be going against the grain to try and take section 33, make it compliant, and then imply exclusivity. Because you couldn't imply exclusivity if it wasn't compliant. Under EU law, you can't simply say it's exclusive, it's not EU law compliant, tough. So the court considered, well, do we imply exclusivity? Can we imply exclusivity under Mar leasing? Lord Walker, no, it goes against the grain. And just to take it quickly from my skeleton, pick out there the wording of Lord's assumption, just reading from paragraph 23. It was not suggested in FII 2012 that the limited remedy in section 33 could satisfy the virtually unqualified obligation of the UK to provide an effective means of recovering tax overcharged contrary to EU law, pausing there, not our case. There is no section 80 claim here, there was no overcharged tax, but this is the important point. Radical surgery would be required to render it conforming, with very much doubt that this torture being a quote from Lord Assumption, could be justified even under the Mar leasing principles of construction. So that's FII 2012.
But you say we've got beyond that because BTCA has already done the surgery and it wasn't too torturous or radical for them.
Straightforward. In the upper tribunal's recent decision, I think readily done or straightforward with the words used. So it's...
Well, it doesn't even matter how difficult it was. They did it. And the parties are stuck with the fact they have done it. And your submission is that means we're not in the same territory as FII.
And it means that the insolvency condition is not an obstacle to exclusivity in the way it was in FII 2012. In other words, if this court finds BT only had the old scheme, nothing else, the old scheme was exclusive, there can be no complaint from an EU law point of view. because we know that BTCA considered that the old scheme was sufficient. Gave sufficient protection, in other words, to its EU law, to BT's EU law rights. That's why they rejected the idea that it had to be resuscitated. That's why GMAC Court of Appeal rejected the idea that you have to retrospectively apply the new scheme or make Section 80 applicable, because both these Court of Appeals considered, yes, it has the insolvency condition, you've had decades, European law has been around for a long time, the old scheme was sufficient, don't come complaining in 2014 that your EU law rights were not given sufficient protection. They were. It's in that context that we say this court should feel free to find exclusivity if it sees it in the features of the old scheme. It's not a problem in relation to EU law in the way that it was a potential problem in FII 2012.
Can that be summarised as there isn't an EU law problem in holding the old scheme to be exclusive because it has already been held that the old scheme is sufficient to vindicate BT's EU law rights. That's what you're saying.
My lord, yes.
So the fact that there are EU law rights involved and that the insolvency condition was unlawful doesn't prevent a finding of exclusivity.
Precisely. And as I say, my learned friends, as I understand it, main objection to that is reliance on FII 2012, and it's just not this case.
Thank you.
But importantly, the judge below said, even if, remember this submission is made in the context of, I say there's an exclusive feature, the insolvency condition. The point taken against me is you can't rely on that condition to say it's exclusive because after all we've got rid of that. We need to get rid of that. But that's what the judge below did. He said even if
81, 82.
Even if we ignore the insolvency condition, there's still left in the scheme features that support the view that on its proper construction it was meant to be exclusive, it was intended to be exclusive. The fact that a claim needs to be made and the regulations that remain intact, and I'll go to those in a moment. And of course we know it provides for appeals to the statutory tribunal, and that was said to be important in paragraph 14 of CPAG. But I also, just as an aside, as it were, point to the difficulties we've had in these proceedings by having the tribunal procedure and the common law claim procedure. The common law claim was stayed in 2010 for 10 years, and it was stayed again revived and then stayed again in 2020, awaiting the upper tribunal decision. So there is this other aspect of...
And the tribunal has a statutory appellate jurisdiction and could not have entertained the common law claim even if it had wanted to. So you had to have parallel proceedings in different tribunals.
It had full powers to uphold, to give effect to EU law, of course, in the statutory appeal arena, but not to find that there was a restitutionary claim or anything like that.
Yes.
It would be limited to provisions in the Act, Section 80, old scheme, and so on. If we look at the regulations quickly,
I'm sorry.
No, that's...
Just jumping ahead a bit, but the 9-month claim, how did that get before the tribunals? Because, as I understand it, the old scheme didn't apply or wasn't thought to apply.
Well, I'll be corrected on exactly what happened at that point in time, but the way it arrived is the claim letter that was written to HMRC regarded the January 78 all the way through to 1989 period. So it said, and I took your lordship yesterday to the points in BTCA in the upper tribunal where they said definitively that was a claim under the old scheme. HMRC looked at the letter, said, no, you're out of time, and went up to the tribunal. And then my learned friend had to, of course, stay within the jurisdiction of the tribunal. So for the 9-month claim, I think the weight of his case, if I can put it that way, was Section 80 rather than the old scheme.
Right, that makes sense.
So there was that procedural gateway.
Yes, I see.
That jurisdictional gateway, I should say. And of course, HMRC's position was not a point for us today, but the 9-month claim in any case gets swept into the old scheme. And so there's jurisdiction that way. If we look at the regulations quickly, it's Volume 1, Tab 5, page 22. And if I run through them, Regulation 3, save as the Commissioners may otherwise... Sorry, does the court have the page?
Yep.
Page 22. Regulation 3, save as the Commissioners may otherwise allow direct, the claimant shall make a claim to the Commissioners by including in Box 8 of the return, described in paragraph subsection 2, the correct amount of the refund. So this is a scheme where you're told you have to make a claim and told exactly how to make a claim. Regulation 4, save as the Commissioners may allow the claimant before he makes a claim shall hold. A has to go because it's the insolvency requirement, and then but B stays. A copy of the tax invoice which was provided in accordance with Part 3 of the principal regs. And then C, records or other documents showing that he has accounted for and paid tax on each taxable supply upon which the claim for a refund of tax is based. Regulation 5. Save as the Commissioners may allow, the claimant shall preserve the documents, invoices and records which he holds in accordance with Regulation 4 for a period of 3 years from the making of the claim, in order ... to furnish it to HMRC and so on. If I can drop to Regulation 8, where the claimant fails to comply with Regulation 5 of these regulations, he shall repay to the Commissioners the amount of the refund by including that amount in Box 4 of his return. So a failure to keep the records that the old scheme specifies must be kept meant that any relief had to be repaid. Nothing like that under the common law. And my learned friend said yesterday, I think, that, oh well, even if you got your bad debt relief through a common law claim, that could somehow be clawed back. Didn't explain how it would be clawed back under the common law, but in any case, Parliament is clearly setting out here how it wants it to be clawed back. We can get it back if you don't keep for 3 years the documents we say you need to keep, showing the invoicing and the accounting for tax to HMRC. And if we get it back, this is how you need to give it back to us, through the VAT return. And Regulation 7 Regulation 7, if I can summarise, deals with how the consideration that was actually received by the supplier is to be attributed to different supplies if these are at different rates. So it's true it refers to where before the debtor becomes insolvent, the supplier gets some money, but before he becomes insolvent isn't relevant. This Regulation 7 is trying to say, how do we attribute the payments that you did get when there's part payment? And the reason that problem arises is, if I can give an example, a trader makes an exempt supply for £10 and also makes a taxable supply for £20 and gets a part payment for those supplies from its customer, £5. It's important to know, does that £5 go to the exempt supply, in which case HMRC can't have any of it? Because exemption means that tax isn't, output tax is not applied. Or does that £5 part payment go to the taxable supply, in which case HMRC is entitled to some of that? And that's what Mr. Justice Miles below means when he says working out the outstanding amount under the regulations is controlled by Parliament, sets out how one attributes this.
It could be done at common law. I mean, there are rules about appropriating payments to debts. Your point is Parliament's chosen this rule, which indeed, I mean, I think at common law, it's up to the debtor to appropriate his payment to whichever debt he wants to, and if he doesn't, then the creditor has a choice as to which debt to appropriate it to.
Well,
but Parliament said, well, no, we're not having those common law rules, we're having these rules.
I think it's the payment nearest to the insolvency, so the most recent. The insolvency bit isn't important though. It's the recent.
No, I think the debt is attributed to the most recent. So you treat payments as paying off the oldest ones first.
Can I make this general response, if I may? The point, and I'm afraid I don't know how it works, the attribution in the common law, and I apologise, but the point isn't how did it work in 78 or how does it work today. The point is that Parliament was saying, we don't care how it works. This is how it will work for bad debt relief under 11C1.
Can I just ask this? Is there a way, other than by proving the insolvency and producing the relevant documents within these regulations, in which the fact that the debt is bad can be proved? You've shown us the attribution rule, but that's for a particular situation which may or may not arise. Is there any other general way in which the taxpayer has to establish that the debt is bad?
Well,
I think the answer must be no, because it's only the insolvency.
No, if the question is...
So we're left with that gap that my lord was referring to earlier. If we're reading things out or eliminating them or moulding them, there's got to be something read in.
Not a problem for this court because the TCA decided that it could be done.
Yes, quite. Not without telling us how, which is in some ways a difficulty with the exclusivity question, because we're left with some uncertain wording, some uncertain statutory wording.
Forgive me, I don't see that goes specifically to exclusivity, because if it's a problem that the old scheme can't be read in a workable way, absent the insolvency condition, then that's a problem whether it's exclusive or non-exclusive. The answer is given by BTCA that it can be properly construed. The assumption must be made by this court.
So my point is just a narrow one, that normally when you're construing one bit of a statute, you look at it in the context of the other bits and what the words are. But we don't know what the words are. We just know that they've been moulded to be different from what they actually are. It may not be a problem, because you say it doesn't actually affect the outcome, but it's an unusual scenario to be in.
Yes, but wouldn't, it's a bit of speculation on my part, but it has to turn ultimately on evidence. BT would consider one day this debt is bad. We provided them with the phone services, we sent them the invoice, we gave them 30 days to pay. It's been 2 years. We sent chasing letters. Yes, we didn't carry out the insolvency aspect, but we did everything we could to get our money back. Because after all, traders want to get their money, not just for that purposes. So we took all these reasonable steps. We considered the debt as bad. And the court would have to make a decision on whether that was shown to be the case or not. Yep. Wouldn't have the ready-made insolvency condition to apply. Now, if is the court happy for me to move on? So if I could turn to the actual repeal of the old scheme and the relevance of that, another point that Mr. Justice Miles made below. Clearly, a repeal in 1997 can't in itself tell us what Parliament meant by enacting the scheme in 1978. But we say it is relevant because by enacting a specific scheme covering supplies from a certain date, here October 1978, Parliament would have also considered that it had control as to shutting down of that scheme. And of course the shutting down would have to be EU law compliant, notice would have to be given and so on, but we know that that is not a problem in our case. But Parliament, in other words, would not consider that it would be at the mercy of common law remedies and their limitation periods. It would consider, we've set up this scheme, this is how you use it, and obviously you can take it away with proper notice. It had control.
How can the fact that Parliament assumed it had control in 1997 affect what it thought it was doing in 1978?
I haven't explained it properly. I don't mean to rely on the 1997 point in time. I'm saying when enacting a special scheme in 1978, by enacting a special scheme, Parliament could have taken itself to have control also as to when to bring it to an end.
Well, certainly control over the contents of it. I think you're saying that the repeal does no more than emphasise that Parliament must have thought that what it gave it could take away, subject to EU compliance, as well as changing the conditions if and when it thought it should, again subject to being EU law compliant.
That is one point, but that's standing in 1997. I also want to stand in 1978.
No, I've explained it badly. You say it's proving the point that Parliament must have had all that in mind in 1978.
Because what are the options here? Parliament could consider that bad debt relief was at the mercy of common law and any remedies that common law had or developed and so on. Or it could consider bad debt relief is in our control. This is how you access it. From October 1978 supplies onwards. And there's no reason to doubt that it would consider that it could also close it down without worrying about those common law remedies in the...
Or it just didn't think about it.
Yes, or it just didn't think about it. But remember, we're not trying to actually identify what was
in the minds of the legislators. That's not what we mean by the intention of Parliament.
Absolutely. It's trying to understand what Parliament could have been trying to do here. It comes up with as I said before, it leaves aside all the price reduction stuff and all the other things, and it grapples with what to do with bad debt relief and what to do with bad debt relief given the uncertainty of when a debt is bad. And it comes up with the old scheme and the insolvency condition in my submission, but even without that, this is how we're going to do it. We're going to do it as an optional claim to relief, and this is how you make the claim in this box. These are the records you keep, so HMRC can inspect, and this is how we do the attribution. And if you don't keep the records, and HMRC knock on your door and say, where are the records, and you don't have them, you have to pay them back. This is what Parliament thought it was doing. And I say, as a part of entering into that world of specifying exactly how it was all to be done, it's not a reasonable construction of parliamentary intention to say, and it thought that it was at the mercy of common law limitation periods. It didn't give a limitation period, but it, as it transpired, as it turned out, it did consider it could close it. And it was right. It could close down the old scheme in an EU law compliant way. And I think, at least in my learned friend Skeleton, he takes the point that, well, it's an implied ouster, it's not an express ouster. That, of course, only goes so far. Implied ousters are found, including in tax cases. Perhaps the explanation is that Parliament doesn't consider, at the time of the relevant provision, that it needs to have some sort of express ouster. The point doesn't matter. Yes, of course, my job is harder with an implied ouster, but there's no way, that's not a sort of starting point that I shouldn't be able to overcome. In Littlewoods, just by way of example, tax case, it was about interest under Section 78. There was no implied ouster, even though the brother provision, Section 80, had an express ouster.
Sorry, there was an implied ouster.
Sorry, did I say?
You said was no,
Yes,
but you meant
it's
there was.
Sorry, no express ouster is what I meant. So
There was an implied ouster, and that's 2 sections away from Section 80, which has an express one.
Precisely. So the circumstances are that Section 80 express ouster, Section 78 just before it, no express ouster. And moreover, I think in that case it had words that implied that there was some other statutory provision. I'm sorry, I thought I noted the word.
It says something like, this is without prejudice to any other right to claim interest, or something like that. So it's actually, it appeared to be
Non-ouster.
an express,
Exactly. So
non-exclusive provision.
and I'm sorry, I
But
find the paragraph is probably my skeleton.
Littlewoods was, I mean, it's an EU law. It was a case where EU law principles were applied, obviously. So there's that element to it. I think. But anyway,
well, so EU law principles, they were applied there in favour of HMRC, as in EU law says you're entitled to interest, doesn't say what kind of interest. Question, do you have compound interest?
Yeah.
Under the common law, you just stuck with statutory interest. Statutory interest under Section 78. And the Supreme Court said statutory interest, even in those circumstances, implied ouster statutory interest under Section 78.
Yes.
So, as I say, it's not about a head count of how many implied law cases I can find, but just to show that as an example. And also ITC, investment trust companies. And what was said in ITC was, sorry, I was going to set it out in a lot of detail, but I'll try and summarise it. The position there was that it was a VAT case, and of course you have the supplier and you have the supplier's customer. And Section 80, subsection 1 says the suppliers must account to HMRC for tax. Sorry, I've said that in the wrong way. Section 80 gives a remedy to suppliers where they've over-accounted for tax. It doesn't say anything under Section 80, subsection 1 for customers, because after all, the customers of the suppliers don't account to HMRC for VAT.
I mean, the question in ITC was whether the customers had a direct remedy against HMRC, and it was held they didn't.
Yes, but the position was that the customers brought a common law action against HMRC, and the specific question I'm relying on is, could they do that? Could they bring a common law claim, or was there something in Section 80 that ousted that claim? Because on its face, on the first look, Section 80 and its ouster seems to be talking about suppliers only, because after all, suppliers are the ones who account to HMRC for VAT, and if they say they think they've overpaid VAT, they bring a Section 80 claim, Section 80, subsection 7 says, and you can't bring a common law claim. The question in ITC was, what about the supplier's customers, the lead claimants? Can they continue with a common law claim, or is their claim ousted by Section 80? And if we turn it up, it's volume 5, tab 52, page 1369. Can I first just go to a point that I'll be relying on in issue 2, just because while we have it open. Page 1380, paragraph 5. The managers, i.e. the suppliers, I'll call them manager suppliers just to keep the position clear. The manager suppliers were obliged to account to the commissioners for the VAT due in respect of their chargeable supplies during each accounting period. It's relevant to note that the obligation to account for tax arises whether or not tax is charged on the supply or paid by the customer. It's the supplier rather than the customer who's under a liability to the commissioners, and it's the supply rather than payment by the customer which triggers the supplier's liability. As I say, that's a point I rely on because I think one of the points my learned friend makes is, under issue 2 is, well, it's not really, there's no real obligation to pay, it's all dependent on whether we actually get paid from our customer, and I'll deal with that in a moment, but I'll refer back to ITC. And then if we look at the key paragraphs on exclusivity are 82 to 87, and again, because of time, if I could try and summarise, the Supreme Court took two positions, in effect, on the question whether the common law claim by the customers was ousted. First was to construe the express ouster clause as covering the customers, but the second, in particular set out at paragraph 87, was to say, well, even if there was no express ouster clause, we would imply one. And the reasoning, summarising paragraph 82, was that the claimants didn't need a common law remedy because although they couldn't bring themselves a Section 80 claim against HMRC, they had sufficient protection through the subsection 3 provisions, which is essentially required a supplier to pass on any repayment it got from HMRC onto the customers. And of course, for any additional amounts, the customer had a common law claim against suppliers, therefore didn't need a claim against HMRC. The second reason was limitation, because there was a limitation period in Section 80 vis-à-vis suppliers' claims. Parliament wouldn't have intended customers to bring a common law claim for longer periods. think it's paragraph 85 and 86, where the Supreme Court says the fact that Parliament wouldn't have known of a future cause of action and mistake was irrelevant. It wasn't an obstacle to exclusivity. My learned friend accepts that point, hasn't appealed against it. See paragraph 19 of our skeleton. And then paragraph 87, the court says, more fundamentally, the determining factor in the present case is that the scheme created by Section 80 is inconsistent with the existence of concurrent non-statutory liability on the part of commissioners to make restitution to consumers. In the absence of Section 80, subsection 7, one would therefore conclude that Section 80 impliedly excluded such liability. Given the express exclusion in Section 80, subsection 7, it is unnecessary to rely on implication, because construing Section 80, subsection 7 has the same effect. I could summarise, I've taken it perhaps too quickly, and this is a further point. What happened in ITC was that everybody had paid tax, thinking the supply was taxable because it was taxable under domestic law. And there was a CJU decision saying the supply is exempt. And that's why there were attempts to recover. As I said yesterday, Section 80 is the go-to, is what you use if you want to say, I paid tax because under domestic law it was taxable, but in fact, CJU has told us it's exempt. Now, there was a certain problem in ITC because the suppliers were out of time in certain cases, the dead periods, to bring a Section 80 claim. And the claimants, the customers, were saying, well, it's all very well to say we can go after the suppliers in our common law claim, so we don't have to go after HMRC. But when we go after the suppliers in our common law claim, they'll have a defensive change of position because they accounted to HMRC and they're out of time now to get that back from HMRC and pass it on to us. And the Supreme Court said, well, that's fine, because there was nothing wrong with the limitation period that was imposed on the suppliers. This wasn't Fleming, it was post-Fleming. So there was nothing wrong with the limitation period. And I say that to emphasise that EU law not only obviously wants to give effective protection to traders, but also is content that their rights can be ended through a limitation period, or in our case, shutting down of the old scheme. As long as that's in an EU law compliant way, which BTCA has already found that it was. I can take up another objection my learned friend raises in his skeleton. The main objection, as we understand it, is that the old scheme, if the old scheme is exclusive, it can't be exclusive of a mistake-based claim, which is parasitic on the failure to use the old scheme. So I'm not quoting my learned friend's skeleton, but the gist of it is, well, fine if it's exclusive, but surely it can't exclude my claim, my common law claim, because my common law claim depends on the very failure to use the old scheme. And we say in response to that case law, of course, makes clear that the court's approach is to identify relevant parliamentary intention if the court considers that the old scheme was exclusive, of course it would be exclusive also of a claim based on the failure to use the old scheme. It's unthinkable that Parliament would intend the old scheme to be exclusive, but not in cases where the old scheme train had been missed. And my learned friend's next step is to say, but I missed the old scheme train because of the insolvency condition. That's no answer either, because limitation periods apply because of the importance of legal certainty and finality, even where the domestic regime is non-compliant, and even where the trader runs out of time before it's been established to be non-compliant. For that proposition, I rely in particular on Leeds City Council, volume 5, tab 48, page 1189. If I can just summarise the facts. Under Article 4, subsection 5 of the Sixth Directive, Leeds City Council should not have accounted for tax, as it was a public authority. The UK hadn't implemented Article 4.5, but it had direct effect. So Leeds had accounted for tax, which was, as a matter of EU law, not due, and brought a Section 80 claim, relying on the fact that it wasn't due under EU law to get a repayment. But the problem was that it was out of time. So it faced limitation under Section 80. And it sought to argue, well, in the special circumstances of the case, after all, the UK hadn't implemented for Article 4 properly. Limitations shouldn't apply. And if I just go to 2 paragraphs on page 1202, paragraph 41, this is the Court of Appeal. So far as the first point is concerned, it's clear as a matter of EU law that the fact that a member state has not properly transposed the directive does not preclude the taxing authorities of that state from relying on a limitation period against the person asserting a directly effective right. Fantastic, which is in my additional authorities bundles if needed. That case concerned a provision in a directive that had been wrongly transposed, rather than a case in which provision had not been transposed at all. Mr. Ghosh says that in principle there can be no difference. Mr. McNabb agrees, and so do I. There is nothing in this point. 43. So far as the third point is concerned, there's no rule of EU law requiring the running of a limitation period to be deferred until the existence of a right to recover the payment has been judicially established. It's not uncommon for a claim to repayment to have become time-barred in national law, while proceedings are still in progress to determine whether the member state was in breach of EU law. They cite their Lord Sumption in FII 2012, paragraph 151, it's in the bundle, because it's the torture case, the radical surgery case. Thus, the fact that HMRC advanced a view of the law, which is now conceded to be wrong, does not preclude reliance on the limitation period. If a taxpayer is dissatisfied with HMRC's view of the law, the proper course is to appeal to the appropriate tribunal. That course has always been open to Leeds. Mr. Ghosh accepted that not every contested case would justify an extension of the limitation period. Ignorance of one's legal rights is not a ground for supplying a limitation period. Citing our case, BTCA, Mr. Ghosh argued that he was complaining not merely that HMRC were wrong, but they'd thrown Leeds off the scent by failing to mention Article 4.5 at all and focusing on what turned out to be legally irrelevant arguments. I cannot see that this makes any difference. The provisions of the Sixth Directive were readily available and were, were known to be directly effective, if, as was the case, HMRC were barking up the wrong tree, Leeds could readily have identified the right tree. Again, reference to our case, BTCA. Mr. Ghosh suggested that there was a difference between a case in which HMRC's erroneous view of law was rejected by a tax tribunal and a case in which HMRC acknowledged the error of their ways without such a ruling. In the former case, there'd be no warrant for any extension, but in the latter case, there would. I reject that submission, which would have the consequence that HMRC would be compelled to defend what they knew to be their own erroneous interpretations. So we say that the fact that my learned friend failed to bring an old scheme claim in time, and that failure was tied to the insolvency condition, doesn't mean that if this court considers the old scheme was intended to be exclusive, it should find that, yes, exclusive, but not for a failure to bring a claim under the old scheme. As I've said, it's precisely in such cases that statutory provisions that are exclusive are intended to bite. You don't miss the old scheme train and then get another go for failing to get on the train. Now, there's two, in my submission, important points to bear in mind in considering exclusivity. So it's two important corrections in my submission I need to make to what my learned friend said yesterday. A point my learned friend seemed to be making yesterday was that the court should ask, why would Parliament want a trader to have access only through the scheme? But we say the better question is, why would Parliament enact a special scheme if it intended that the trader could ignore it? And the other point my learned friend suggested yesterday was that this court should ask itself which option better provides for EU law rights, i.e. which option would give BT the relief that Article 11C1 intended it to have. Would it be better to give BT a further chance? Would that be more in line with Article 11C1? Or would it be better to find that the old scheme was exclusive and say that's the end, BT? You lost under the old scheme, you lost under Section 80, end of story. With respect, we say that that's not the court's job. The court has to ensure minimum protection is due to BT. Sorry, minimum protection is given to BT to ensure its EU law rights are sufficiently protected. The court doesn't ask itself which is better, it just has to ensure that those minimum principles of effectiveness are respected. And happily for this court, that's already been decided in BTCA. And beyond that, this court simply asks the exclusivity question. Did Parliament, looking at the scheme and its features, did Parliament intend it to be exclusive?
It's the same point you've already made, that you don't need to find the scheme to be non-exclusive in order to give effect to EU law rights, because it's already been decided in this case that the EU law rights have been vindicated by the old scheme suitably moulded.
Yes. To deal very quickly with another case my learned friend went to, FII 2014 in the CJU, for the point that EU law permits a choice of remedies and protects whether it's who protects them. That's right. if, my learned friend, if BT had two remedies, EU law would apply to both. So it would not be EU law compliant to retrospectively change a limitation period or anything like that without a transitional period. But that doesn't help this court at all. It's question begging. Question for this court is, does BT have more than one remedy, or is the old scheme exclusive, such that it only has one remedy? So FII 2014 does not take it any further. My learned friend's next complaint was that the pre-existing remedy cannot be ousted by implication. Now, whether that's right or wrong is simply irrelevant, because there is no situation here where we have a pre-existing remedy that the old scheme comes along and retrospectively ousts, because the old scheme applies to supplies from October 78. My learned friend can't complain that bad debts in relation to earlier supplies attracted some remedy that the old scheme is retrospectively and impermissibly trying to oust. I explained yesterday that I'm not relying on exclusivity for the first 9-month claim period. I'm not saying the old scheme was exclusive retrospectively.
You'll have to come under issue 3 to what BT's EU law rights were for the 9-month period and how they were given effect to.
Yes.
Because it's not the old, as I understand it, you're not saying it was the old scheme that gave effect to them.
No, not in this strikeout.
Not in this strikeout.
In this strikeout, I'm taking it as read that
yes.
I can't rely on that point, and I'll come to issue 3, yes.
Yes.
But the point here, and we're under issue 1 and exclusivity, is that my learned friend's argument, the references are all in our skeleton, cross-referring to my learned friend's original skeleton. We're not saying that the old scheme was exclusive retrospectively. So when my learned friend refers to legitimate expectations and so on, no trader can have some legitimate expectation in relation to a claim based on a failure to use the old scheme before the old scheme was enacted. So I say that point goes nowhere. BT's further complaint is that as BT has no Section 80 claim, no right, in other words, to statutory restitution, it'll be left without an error correction type remedy. We say that too goes nowhere. BTCA saw no difficulty with saying you can't have a Section 80 claim, because, returning to the theme, BTCA and GMAC GMAC Court of Appeals considered that the old scheme gave sufficient protection. And I think my learned friend said that he wasn't clear on a point made below about Section 80 and the old scheme and how they work together. And if this is an additional point that the judge below made, that the old scheme and Section 80 were separate, and that the old scheme excluded Section 80 claims once Section 80 came onto the statute books. The point made there is that on its proper construction, that given in BTCA, whether with or without the insolvency condition, the failure to use the old scheme doesn't give rise to a Section 80 claim. argument is that it's quite consistent with that to construe the old scheme as excluding the common law restitution claim also. I'm coming to the end happily ahead of my extension. So another point that BT claims is that we're guilty of relying on a circular argument. That when BT says it has a common law remedy for failure to use the old scheme in time, it's no answer to say, but BTCA decided you did have access to the old scheme. That's the circularity that we're accused of. But we say, that's not, of course, all we're saying. The position is this: BT had access to the old scheme. The old scheme had key features evidencing an intention that it be an exclusive remedy. And if BT failed to use it, that's not a reason to doubt its exclusivity. Where Parliament does intend the statutory remedy to be exclusive, it's unthinkable that it doesn't also intend to exclude what I've referred to as the parasitic remedy, that is, a remedy based on the failure to use the exclusive remedy.
You described it more than once as a failure to use the old scheme. It's more accurate to say the claim that they wish to advance is a failure by mistake to appreciate that they could use the old scheme.
Yes, it's a mistaken failure to use the old scheme in time.
Yes, but it's premised on they didn't understand what the law was.
Yes, so they didn't, as I say, if I concede anything, it's only for the purposes of the strikeout, it's not for if we go on. But a mistake of law was made, they say, didn't appreciate our EU law rights could be given effect through the old scheme and so on, and were thereby enriched HMRC. How do we enrich HMRC? Because we didn't bring a claim in time. So HMRC is walking around with money that we have, but for our mistake, could have got back. That's the sort of gist. And when I come on to issue 2, I'll untangle. My lord made the point yesterday. I'll untangle the various versions of that my learned friend makes. But however it's put, why would Parliament not intend to exclude, given it's generally exclusive, why would it not intend to exclude some claim, however we untangle it later on today, that's based on a failure to use the old scheme in time, for mistake of law reasons, for whatever reason?
So your point is, if Parliament sets up a scheme, and if on its true construction it's intended to be exclusive, then that means not only you can't bring some other claim that you would have had, but you can't bring another claim based on the fact that you didn't realise that this was your exclusive remedy.
Exclusive means exclusive. Exclusive.
Would that extend to a claim based on misrepresentation? Suppose that the state had misrepresented the position positively. Said, well, you can't bring, under EU law or otherwise, any claim to bad debt relief other than the one that we've set out in this statute.
Well, it all depends,
and they relied on
doesn't
that and
it?
suffered the damage that they claim. Would that be excluded too?
Well, it all depends on obviously the statutory provision and how a position is particularly put. But what we're dealing with is my learned friend saying, well, I didn't use the old scheme because I didn't realise I had a claim. Perhaps I'm not quite answering the question. Exclusive means exclusive of everything, unless my learned friend can give some reason to doubt that exclusivity. So you start with the provision. You say, is it exclusive? And then, of course, you can change that prima facie position of exclusivity because there's some objection to it.
Well,
one objection might be...
Yeah, sorry, you finish what you're saying.
And one objection might be potentially some sort of misrepresentation position. One objection might be, it can't be exclusive because that doesn't give sufficient protection to my EU law rights, which is BT's argument, but we've answered that through BTCA.
I think my question is more directed at an earlier stage of the analysis, where you're asking and trying to answer the question of whether this is an exclusive scheme. One way of putting it, I just want to put this to you, is when you submitted earlier that the old scheme covers the same ground as the putative common law remedy that is advanced, might it be said that the right being exercised when one makes a claim under the old scheme is the domestic statutory right to, and I'm quoting the statute, a refund of the amount of tax chargeable, which is an implementation of the Sixth Directive. It doesn't matter for this purpose whether it's moulded or not. But the right that's being claimed is a right to compensation for the consequences of failure to exercise that statutory right. I think your answer is have a look at CPAG and other authorities you've already cited to us. But that's what I understand one of the core propositions to be. So it's not the same ground, even though the right in 11C1 is a feature of both claims.
Can I answer that this way? It's not just a feature, it's fundamental. It's the starting point. The only reason that anyone is looking for any relief, the only reason that anybody's ever going to get any money back from HMRC in these circumstances is because of 11C1, saying that under conditions set by the member state, taxable amount shall be reduced in the cases of partial or total non-payment. So my lord is right. My learned friend tries to take the point that it's not the same ground because, an old scheme claim is for bad debt relief. My common law claim is for failure to use the old scheme in time to access the bad debt relief. But that's a sort of sleight of hand because obviously then any putatively exclusive remedy when missed would never really be exclusive because a trader could come along and say, well, it's not exclusive of this parasitic remedy. This is where I didn't access the exclusive remedy and now I'm looking for relief from that mistake.
It's the same money. It's the 65 million.
And the foundation of the mistake is 11C1.
Absolutely, that's
So, as in the correct legal answer is 11C1. That is that's what the mistake relates to.
absolutely.
So I think, if I understand it, your position is a trader such as BT has accounted for 65 million of VAT, which it later turns out it never recovered from its customers. How does it get it back? And your position is Parliament has said how you get it back. It's the old scheme. BTCA in 2014 said that works to get it back. You have to do quite a lot of moulding to it, cut bits out. As my lord said, you have to put something else in place. It's not obvious what, but it doesn't matter. It's already been decided you can do it. As far as Parliament's concerned, that's it. That's your remedy. You don't have another remedy. You're not intended to have any other remedy. And if you're right on that, you say you must be right also, but you can't get around that by saying, But my complaint is I didn't realise I could use it. Because you're still trying to get back the same money.
And BTCA, I made this point yesterday, BTCA said that it was sufficient protection of EU law rights in the full knowledge, because after all it was its own decision that the insolvency condition was unlawful. It found that it had direct effect. It found that BT actually didn't know. That's why it refers to ignorance of one's rights as no excuse. So it was aware of all the circumstances. BT didn't know. It made a mistake of law, presumably to some extent understandable, because after all there's the insolvency condition. But BTCA says that doesn't matter, because you had advisors, you had decades, EU law's been flowing through our estuary since whatever it was it said. You had every opportunity. So you can't complain now that you're out of time, and that your being out of time should be disapplied, i.e. disapply section 39, subsection 5, resuscitate the old scheme, and so on. And I said yesterday, it's not that I'm not saying that BTCA had exclusivity as an issue before it, but in saying what it said, that the old scheme gave sufficient protection, in not considering that it had to find some other remedy for BTCA, either through section 80 or, in the case of GMAC, some retrospective application of the new scheme and so on. It means that these obstacles that my learned friend is putting in the way of exclusivity fall away. And if and when the court looks again at our skeleton argument, we point to the paragraphs in my learned friend's skeleton where it's clear that there's a sort of almost acceptance of exclusivity under the old scheme, but my learned friend's arguments really are, sure, it's sort of exclusive, but it won't be in this case, because after all it's based on a failure to use the old scheme. And after all, it's an implied ouster, and you can't have implied ousters for ousting pre-existing common law claims. So these are the arguments I've just gone through. There was no pre-existing common law claim that the old scheme, we say, ousted. And the last point I make, slightly blindly, if I can explain, this is the last point on autologic. As I say, I'm going to go to this for issue 2, and that's why it's in my authorities bundle. My learned friend says that he wants to deal with it on issue 1. So that's why I'm slightly blind here. But as I understand it, what my learned friend is saying, I'm sorry, I'm not sure of the tab. I think it's tab 2
in the additional bundle.
If I could summarise the relevant bit, there were claimants who were bringing common law claims, and the issue was whether those claimants should, I think it was stay those common law claims in order that they pursue statutory remedies. And the House of Lords said in one category of cases, yes, you have to go through your statutory remedies first. The tribunals are well equipped to provide you with protection of your EU law rights, follow the statutory procedure, underlying procedure. And for the other category of claimants, the House of Lords said, well, one problem you have with the statutory procedure is you're out of time. But still try for the statutory procedure because you might get an extension from the tribunals. And it said for all the others, and I'll go through the relevant paragraphs in a moment, for the others it said, if you can't get your remedy through the statutory procedure, then you can come to the common law. I think my learned friend will say, aha, I too, BT can't get satisfaction from the statutory procedure, therefore it must continue in the common law. But the reason I say autologic can't help him is that there is no assumption of exclusivity of the remedy in autologic. It's not about exclusivity of the remedy. It was the House of Lords saying, where Parliament set out statutory procedures, follow those. At least follow those in the first instance. Follow those if at all possible. And we made the autologic point when we got the stay of the common law claim, or appeal rather, pending the decision of the upper tribunal. Spoke to autologic and said, look at autologic, let's finish the statutory appeal first before we come to the common law and argue whether there should be a common law claim and all the other issues that are before this court. But I say that autologic doesn't proceed on the assumption that the statutory remedy itself, not the procedure, the statutory remedy was exclusive and yet said, but you can still go to your common law claim because that's required by vindication of your real law rights. And of course, again, BTCA not required for vindication of BT's EU law rights. In my last 5 minutes, if I could just literally go through the the key points at 18, paragraph 18 to 31. And if I summarise, pick out bits as we go. Paragraph 19, as I see it, the claimants fall into two broad classes. One class comprises cases where if the claimant company's contentions and community law are well founded, still open to the company to obtain relief to which on that footing it's entitled. The other class comprises cases where the course is not open to the claimant company. Dropping to 20, in my view, the former of these two classes, Category 1 claims in the High Court are misconceived, where a claimant company can obtain, through the statutory underlying procedures, the very tax relief whose non-availability is complaining, see no justification for the company bypassing that route and coming to the High Court. ... Paragraph 23. In my view, these claims in the High Court are prima facie misuse of the court's process. And then 28. Sorry, I've possibly taken it too quickly. 25. Appeals to the special commissioners where novel points of law arise are part of the ordinary statutory procedure. Usually the points of law concern UK tax legislation, but a dispute on the interpretation and application of community law, then we need to refer questions to Luxembourg, do not make the case fundamentally different. Once the interpretation and application of community law has been clarified by the EU court, the principal difficulty with surrounding these appeals will be gone. Confining claimants to the statutory route with interest and cost consequences just mentioned can hardly be regarded as rendering the route to reimbursement excessively onerous. In my view, and this is moving on to the Category 2 cases, in my view, in each of these cases, the Category 1 claims in the High Court are prima facie misconceived for the reasons set out. They're able to obtain relief through the statutory route. Taxpayers contend that to oblige all claimants to follow this route, especially those who have not yet made group claims to the revenue, would be inconsistent with the approach indicated in Mettergesellschaft Höchst. As matters stand, the revenue are bound to refuse claims for group relief when the surrounding company is not resident in this country. The European Court, it said, has ruled that claimants should not be required to take futile steps of this nature when seeking to enforce their rights in community law. And then the Hurst case is set out. And paragraph 29, Lord Nichols disagrees with the Court of Appeal and says the taxpayers' reliance on this ruling in the present case is misplaced. Taxpayers are seeking to apply the EU court ruling out of context. In Meta-Gesellschaft case, this ruling was directed at rejecting a governmental defence based on the taxpayers' alleged lack of reasonable diligence in pursuing the claim. It was not directed at the situation, whereas here the claimant's claims have yet to be decided in the national court, and there exists a statutorily prescribed route by which the claimants are able to obtain the tax relief they say is their entitlement under EU law, which court or tribunal has jurisdiction to hear disputes involving rights derived from community law as a matter for each member state. And then if I could ask the court to note paragraph 30 and 31, simply because it's faster if the court reads it than if I do. So the point there was follow the statutory procedure, follow it as far as possible. That's your primary route. In certain cases, if you need to use the common law remedy, then and only then come and use it. But that I can't see anything in autologic that assumes that the statutory remedy one would seek through the statutory route was exclusive. In other words, autologic doesn't cast doubt on issue 1. It's to do with where do you go? Must you follow the statutory route if you have it open to you, or can you ignore it and go to the common law? And promised my learned friend 45 minutes before 1 o'clock, and so sorry, unless of course there are questions.
No, thank you. Thank you very much. Yes.
I'm most grateful to my learned friend. I will in just a moment go straight to what I say one can derive from autologic. But the first point I make is that, as has become increasingly apparent in the exchange between the court and my learned friend this morning about nuances of language between ouster and exclusivity. The concept of exclusivity, I'm happy to try and stay there, because it may well be that ouster is a sub-aspect of exclusivity, but not the other way around. Exclusivity, therefore, is at least calling for a two-tier analysis, with ouster being, as I just said, as a subset, perhaps, of that. Exclusivity a la autologic, I hope to make good in a moment, is while the provision is alive and well and functioning, it is an abuse to go to court and ask for essentially what you would get from the system. And that is my learned friend's case at its strongest. In other words, while the old scheme was functioning, it would have been an abuse. She doesn't put it this way because she doesn't have to go Woolwich say. You would simply use the old scheme as mounted. So that's one type of exclusivity. And indeed, that ultimately isn't necessarily the battleground here. The subset of exclusivity is the one where the fight is. That is to say, obviously, coming to court after the end of the scheme with the sort of claim that we bring. And that, as I say, is a subset of exclusivity. And naturally, for all the reasons I've repeatedly given, a very extreme version. And you have my submissions that that itself would be a battle fought out against, if not perhaps I could be probably over-dramatising it if I said the wreckage of the old scheme having been moulded, but it isn't clear perhaps to anyone, at least on this side of the bar, that exactly what shape the old scheme as moulded has. Therefore, there's a component of legal uncertainty, which I have mentioned, making ouster the more unattractive. But if I can come back to exclusivity and its role in the analysis, without some degree of exclusivity, my claim fails, because my claim is dependent on a lost opportunity. If the opportunity was still there, we'd be in the autologic class 1 situation. And therefore, that there was a scheme and that it disappeared, and it was the only scheme that was on the table. You've seen the list of defeats that we've had on all the other statutory gateways. It was the only non-common law scheme on the table, and that's been taken away. That's an inherent part, as I've said in the past, of the cause of action. It's that further degree of exclusivity which obviously we're fighting about. And that brings me to autologic, if I can ask the court to take it up again. It's a 2006 case, and I think, I haven't checked this, but it refers to DMG in the Court of Appeal. So it would be against a landscape of Woolwich, common law Woolwich, but not yet a Supreme Court endorsement of common law mistake. Nothing really perhaps turns on that, except to say that it was therefore from the taxpayer's point of view, not as strong a position as ours, because I'm assuming that the essential ingredients of a Woolwich claim would be pretty much analogous to the claim in front of the special commissioners, whereas, as you well know, I have the additional ingredients of mistake and so forth. Then if one goes to the judgment, and I'm grateful to my learned friend for having, as it were, given an introduction. The way it's structured is, I think you've already been told, Lord Lords Nichols, Millet and Stain in the majority. A very lengthy, and if I may say so with profound respect, learned speech of Lord Walker. Agreed to by Lord Hull. And if one goes to Lord Nichols first, at 11:12, the giveaway in some senses is in the title, the statutory code, and his lordship in the first couple of sentences says, in resolving this question of jurisdiction, the starting point is to note two basic principles. The first concerns the exclusive nature of the appeal commissioner's jurisdiction to decide certain types of disputes arising in the administration of this country's tax system. The present disputes concern claims for group relief. Where a taxpayer claims group relief depends on whether the claim relates to the accounting period before or after 1 January 1999. Before that date, the corporation taxpayer file system was in force. That's now been replaced by corporation tax self-assessment. For present purposes, this difference is immaterial. What matters is that whichever system is applicable, an assessment which disallows a group relief claim cannot be altered except in accordance with the express provisions of tax legislation. And he goes on to describe the detail of that, and at F, skipping a few lines of technicality, he observes that the appeal commissioner's findings of fact are final, and he refers to the appellate trajectory that follows point of law. And then at 12, we have a statement which is, we say, descriptive of a classic ouster exclusivity Clearly, the purpose intended to be achieved by this elaborate, long-established statutory scheme would be defeated if it were open to a taxpayer to leave undisturbed an assessment with which he is dissatisfied and adopt the expedient of applying to the High Court for a declaration of how much tax he owes and that he already paid the tax in order for repayment of the amount he claims was wrongly assessed. In substance, though not in form, that would be an appeal against an assessment. In such a case, the effect of the relief sought in the High Court, if granted, would be to negative an assessment otherwise than in accordance with the statutory code. Thus, in such a case, the High Court proceedings would be struck out as an abuse of the court's process. Proceedings would be an abuse because the dispute presented to the court for decision would be a dispute Parliament has assigned for resolution exclusively to a specialist tribunal. The dissatisfied taxpayer should have recourse to the appeal procedure provided by Parliament. He should follow the statutory rule. Pausing for a moment, we will see that the minority didn't find that a problem, but they were the minority, and that's just therefore a background comment. What happens in 13, which I won't read aloud, save to invite you to note at B, the taxpayer must use the remedies provided by the tax legislation. I pass then to community law. Having read those passages, this is clearly a case of a procedural ousting for the reasons of which we've seen the beginning. In 16, the second basic principle is said to concern the interpretation and application of the provision of UK legislation, which is inconsistent with a directly applicable provision. Where such inconsistency exists, the statutory provision is to be read and take effect as though the statute had enacted that offending provision, that had enacted that offending provision was to be without prejudice to the directly enforceable community rights of persons having the benefit of such rights. He refers to the ECA. The analogy with the present case is obvious. Then at paragraphs 20 to 21, under the heading of claimant companies which can still obtain group relief, his lordship takes the view, I won't read these aloud, but if I may pause, that their claims should pass through the statutory system. And then, jumping to 27, Lord Nichols says, in my view, in each of these types of case, in the High Court are prima facie misconceived for the reasons set out above. The claimants are able to obtain group relief to which they are entitled by following the statutorily prescribed route. That is the route they should follow. And then he refers to Hurst at F2H, and again, if I might invite the court just to read that. So, if my clients had discovered the situation prior to the abolition, they could not come to court. That seems to be clear. Then turning forward to the analogue of my clients, 39, his lordship says this, line 39. Thus far I have been considering cases where the subject matter of the Category 1 claims in the High Court is group relief claims which can still be allowed by the appeal commissioners if the claimant's community law contention is correct. I now turn to the other class of cases where this is not so. The most obvious example is where it is now too late in respect of the relevant accounting periods for a claimant to make a group relief claim to the revenue or to appeal to the appeal commissioners. The claimant is outside the prescribed time limits. And then he speaks of the paribus. He then observes at 40, which is obvious, time bars of this character are commonplace, and he cites the blessing of the European Court for that at 40. May I invite the court to take it up at 41? In such cases, the taxpayer's remedy necessarily lies elsewhere. In such cases, the taxpayer's remedy is of a different character. The taxpayer's remedy lies in pursuing proceedings claiming restitutionary and other relief in respect of the UK's failure to give proper effect to community law. The appeal commissioners have no jurisdiction to hear such claims. Such claims are outside the commission's statutory jurisdiction, and the commissioners have no inherent jurisdiction. Claims in this class would therefore proceed in the High Court. Difficult questions, both of domestic law and community law, may arise about the time limits applicable to High Court claims of this character. Some of these questions were explored recently in the Court of Appeal in Deutsche and Brenta. They are not matters arising on these appeals. That's the core of His Lordship's reasoning. At 47, Lord Steyne agrees. At 61 and following, Lord Millet agrees. And in his paragraph 62, he sets out 3 principles, and then in the last 5 or 7 lines, a general observation. Once again, may I just invite you to scan para 62, Lord. Perhaps just before I leave the case, the conclusions that I invite the court to draw are either obvious or I will summarise them in a few moments. But before I leave the case, can I invite the court just to look at, either now or inconvenient, 3 paragraphs in the dissenting judgment of Lord Walker. They are 122, 126, and 128. And they were a dissent, they are therefore not the law, but they explain the more expansive approach that the minority would have taken. What emerges, and perhaps to state the obvious, is that exclusivity is a nuanced inquiry. You have to ask where you are in the story and what's on the table to be excluded. Inter vivos, if I can use that, to describe a situation where old scheme was still alive and running. My clients discover they have to go old scheme. Post-mortem, you have my submission that the directly effective right continued to exist, and in line with the approach in autologic, some other way needed to be found. You've got my extensive submission on why that was. But it's obviously a distinction there between layers of procedural exclusivity and an overarching substantive obligation in terms of direct effect. But can I make this side observation? Even if, and it has not been suggested, in some way along the course of events our directly effective rights died the death, we would still be here. It would be a Deutsche Morgan, classic Deutsche Morgan case. It would have just been another nail in the coffin. The battle before this court is to find a domestic route. My submissions are assisted by the enduring nature of the directly effective So that's AutoLogic. Within AutoLogic, as you saw, there was a quote of paragraph 107 of the Hearst case. That was at paragraph 28. Just grateful if I could briefly draw to your attention the two paragraphs that preceded it, namely 105 and 106. The Mattel Gesellschaft stroke Hearst case is at divider 73 of the bundle. That's page 2121. And paragraphs 105 and 106 are sidelined. They are on page 2168. May I invite the court to look at those? And the point that we ask you to take from that is confirmation of the fact that the approach of Lord Nichols, with great respect, is entirely correct, in the sense that had the claimants in the second class been forced down a statutory route, which was a cul-de-sac because they were time-barred, that would have effectively allowed the state to rely on its own wrong by relying on the claimant's failure to use a scheme which was bound to lead to a no. So that, we say, is confirmation of the fact that this is not a black and white situation, Ouster. Can I turn next to the question of res judicata, which my learned friend finished yesterday? She closed with a list of, I think, 5 points, and there was some dialogue between my learned friend and the court as to the detail. Those res judicata are, in most cases, helpful to or an ingredient of my case. If I were coming to this court brandishing triumphant res judicata, it would probably undermine my case because it would be placing my clients potentially in a class 1 situation, a la AutoLogic. It's because of our failures, which my learned friend very properly described, to obtain a statutory remedy, and the trail of res judicata that those failures have left, that we claim to be entitled to bring this claim. I think the first one was that the purpose of the old scheme was to give effect to Article 11C. That's been decided. It's helpful to my case because it indicates that that was the place where we would have found our remedy, but for the language of the statute. The second one was the moulding, and once again, that's part of my case because that confirms that that would have been the door for us to go to. The third, to go through. The third one was the to the effect, according to my note, that BT, the effect that insofar as BT didn't know, it was an irrelevance. Every opportunity had been given. That is I have to pause there, because that is replete with implications which need to be called out and addressed head on. The Court of Appeal obviously made no factual findings. It was part of, I can say this, part of the deal that the parties made with the upper tribunal. My learned junior has supplied me with the paid reference. We lost it, but I'll find it again. The deal that we made with the upper tribunal to go to jump over the first year. Both presidents involved themselves, and they said it was a condition that there would be no factual findings at all. So this matter got to the Court of Appeal with no factual findings, obviously no evidence. To this day, there's no evidence, and no assumed facts. So I accept possibly the least helpful basis upon which to set legal questions. And although the Court of Appeal accepted, as it happens rightly, that the only reason my clients claimed was that they didn't know, one can't go any further, and I'm very conscious that there were certainly implicitly negative elements of what the Court of Appeal said. But the commissioners know what our witnesses would say, and this court has to be agnostic in my submission as to those matters. Save for this, the commissioners very properly do not bring before you any contention that the 32(1)(c) reasonable knowledge issue on the main appeal, I've got a double negative coming, isn't fit for hearing at trial. There's no suggestion. That's the purely factual matter.
Yes, so they haven't taken the limitation point
Exactly.
on the main period for the purposes of this application.
And it's in the I'm so great. In the complexity of it all, it's possible to overlook that. So it's accepted that there's a tribal issue on for which we're grateful, but that essentially balances out any negativity. Perhaps I'm just being oversensitive, which one might come out of the Court of Appeal's decision. The fourth point was, or is, as to the repeal of the old scheme, that it did not breach my client's directly affected rights. And that was ultimately a question of, as a Fleming question, was sufficient notice given? Upper Tribunal said no. Court of Appeal said yes. And therefore, that was our last chance, it turns out, to stay within the statutory system. So that was the moment when that door was closed. It was also closed by reference to Section 80. It's not appropriate or fair for the Crown to parlay that, and my own friend has been tentative, into a finding that the directly affected right was brought to an end. My own friend has not said that. But you've had enough years, you've had long enough. Those statements imply, without ever saying it, that it's all over. It doesn't make any difference to my claim because we've still lost the opportunity. But my claim is stronger if I can pray and aid a living, effective European right, which is yet to be satisfied. And the Court of Appeal simply answered the exam questions. It was set. It did not go any further. That is.
I thought it was part of Ms. Matrafanous's submissions that your directly effective legal rights, it was decided by BTCA in 2014, but your directly effective legal rights could have been given effect to by the old scheme suitably moulded, and it was compatible with EU law to bring that old scheme to an end, and that it followed that that was all that was needed to vindicate your directly effective EU rights. I thought she did say that this morning. I may have misunderstood.
I'm glad I've raised it. At the end of the day, the court said what it said, and what it said is essentially a para 1, 2, 3. And if my learned friend went that far, number one, my mistake claim remains.
I have that point. Your point is precisely because I didn't realise I could have used the old scheme, but I've lost out.
Yes. But, and it's a matter of construction of para 1, 2, 3 of the decision in Ivoco. Well, the question.
Ivoco, or are we
I'm
looking
so
at
sorry.
BTCA?
BTCA.
Forgive me. The questions that the court were asked are at para 5.
Can you give us a page number?
1092, my
Thank
lady.
you.
1092.
Yes, it's issue 2 that's the critical one, isn't it?
Indeed. And the critical difference and the conclusions, my lady, appear at 118, para 118, page 112, 1183 to 124. And what happens at 124 is that the Commissioner's appeal against the upper tribunal's answer to preliminary issue 2 is allowed. And the answer, which is reversed, I'm sorry, we have to go back to 1093, is quoted by Lord Justice Reimer at para 6b.
Sorry,
I'm
sorry,
sorry.
I'll have to go to hard copy. What volume was it? Or term?
It's volume 4, tab
Thank you.
45.
So the trail is para 5, and I should have then said para 6. So page 1597, I'm so sorry, that's the wrong number. Page 1092, then 1093. So at 5, you've got the questions that were put to the upper tribunal. And that includes issue 2, as my ladies said. On the next page, page 1093, at 6b, you have the answer, which I will read. Section 39.5, i.e. the repealing section, falls to be disapplied or construed under EU law in such a way as not to affect the exercise of BT's rights under EU law. This conclusion turns on our view that inadequate notice of the termination of the old scheme was given. Accordingly, BT's claims were not time-barred when they made them in the claim letter dated 30 March 2009. So it's a pure Fleming answer. 3 or 4 months, I think it was 4 months, was enough to be a valid termination. It doesn't go outside that. And I say that the court's reasoning around that conclusion is to be found on page 1129, paras 118 to 123.
Do I understand you to say that the issue estoppel is over the Fleming point only? Is that the number of it?
Yes, that is the number of it. That's what they decided. They wouldn't have had jurisdiction to decide anything about wider common law rights. We know that. So there can be no issue estoppel because you can't have that without jurisdiction. And they didn't purport. It wasn't argued in any event. So 124 is very clear. 123 is quite a compact paragraph and traverses quite a few topics, including my client's awareness or otherwise. So if I can just work through it very quickly. Not sure well, I'll do my best because it's very important. First of all, ignorance is said to be irrelevant, and we accept that it is a rule that time can still run under a time bar, even this is European law rule, even though a party is ignorant of the existence of its claim. That's extremely well established, and if I may say so, not a problem, and was very much in the court's minds in auto logic. Then there's the prudent and circumspect operator point, which is the one I'm describing as somewhat negative. We met that point. So sorry, I've turned two pages. So I've gone back to 1, 2, 3. And His Lordship says in 1, 2, 3, I therefore fail to understand how BT can now say that the eventual demise, etc., had a negative impact. And what His Lordship is saying there is that its disappearance didn't do you any damage because you didn't know it, but it was moulded. And then he deals at the top of page 130 with the 4-month warning point, which was the key point. He then refers to the stale claim at letter B, and then he returns to the question of the adequacy of notice. And he therefore concludes at C, the enactment of 39.5 did not infringe BT's directly enforceable rights. And that's the only question that they were asked, and the only question that they answered.
Well, I'm not sure. There are 3 judgments on preliminary issue 2.
Yes.
As I read the judgments, but tell me if this is wrong, the thrust of it is you did have directly effective EU rights. You could have used the old scheme suitably moulded to assert them. The question before us is whether bringing the old scheme to an end was an infringement of your EU rights. It was not. And the reason it was not was because the UK was entitled to bring the old scheme to an end and hence bring your directly effective EU law rights to an end. That seems to me to be the way which Lord Justice Kitchen puts it.
He agreed.
Look at 133. BT had since 1978 the opportunity to exercise its directly effective rights. I'm prepared to accept that it had, or must be considered to have had a legitimate expectation that it would not be deprived of those rights. That's its directly effective rights under EU law without being given notice which was adequate. But I find that as prudent circumspect operators, 4 months was adequate. So isn't he treating it as being what the Section 39.5 does is bring to an end your ability to pursue your directly effective EU law rights in a way that's compatible with EU law?
He's treating, well, we didn't argue this wider question, and I say that with some confidence because of the first half of the judgment, where the court holds without qualification that we had directly effective rights, that there was no time bar, there was no implied European time bar running in the background, and I will check, of course, over the short term, but I don't recall the court saying, but of course they all ended long ago, because if that had been the case, we wouldn't have had to have the fight about the implicit EU law time bar still running in the background, which the fact that BT won, it would have been a much shorter answer to go to this question first, and I just say, well, that's the answer. They ended in 1989. It may well be that it was a point that was assumed, but it was never debated.
It may not have been debated, but isn't it a key part of the reasoning that the rights are being brought to an end, and therefore the question is whether there's adequate notice? That's the premise.
I accept that, with the, if I may say so, with the caveat that it's the rights to make the claim in the statutory system. That's what the case was about. And of course everybody was thinking about that. We didn't go into the wider afterlife of the rights because there was no reason to do so. The battle obviously was, can we BT fit ourselves into the statutory system, either through Section 80 or through bad debt. That was the battle. Those were the questions. Those were the answers.
Yes, I mean, it's obviously the case that BTCA doesn't decide you have no common law remedies. That's for these proceedings.
Indeed. And it's at the very least, I would respectfully say, it's clear that they do not say that the rights come to an end. There isn't time for me, and I wouldn't trespass on your patience to take you back to the earlier parts of the case, but they are very striking in saying that the directly effective rights are open-ended in time terms without qualification. I wonder if I could just pack a few more quick points in before.
Yes.
So I leave that. I've made the points. I've made the critical points. One question. One comment was made about stale claims. The point I'm going to make now is not a it's not an analytical point, but it is part of the story, which is intriguing. If you would be kind enough to take up Supplemental Bundle 1, you will see at page 2, enclosure 1, the Commissioner's public notice, March 2017, and my purpose in reading it is to draw to the Court's attention that, well, this brief sets out HMRC's position on claims for historical bad debt relief following the Court of Appeal's judgments in BT of 11/4/2014 and GMAC, etc. The readership is VAT-registered businesses that suffered bad debts on supplies they made between 1 January 1978 and 19 March 1997, and that didn't adjust the VAT on such debts. So pausing there, it is, by definition, the audience is people who did not make a claim for bad debt relief. It then goes back to the history, and you see the break in dates between the old scheme and the new scheme, and it sets out what the Court of Appeal found, and it invites claims over the page for bad debt relief. So it was the case, therefore, that the decision did underline the existence of a directly affected right, at least for those under the new scheme. That, for reasons I explained, that right was treated as having crystallised to the point of a public handout to those who had not made a claim under the new scheme some 20, 25 years later. It's only an administrative act, as I said. It's not an analytical point, but it is some practical confirmation. First of all, the concept of stale is very, very broad in tax context, and secondly, that there are certainly, at least for those who were under the new scheme, still directly affected rights, notwithstanding the lack of claim. The final point is, what is the nature of the mistake? Court has raised that question once or twice, and the answer is to be found in the supplementary bundle 1, divider 5. It's both in paragraph 8 of the points of claim, but those are elucidated in the shape of a Part 18 explanation. At page 24 of supplementary bundle 1, where we answer the 32(1)(c) question. So it's a slightly oblique way into it, but that is probably the best place for seeing the pleaded case. The case in our skeleton arguments is at paragraph 43.1 and 51.2. I'll repeat those, 43.1 and 51.2 of our skeleton argument. I've got one other. Yes, and also the top of page 22 of the further particulars, as I still think of them, of the bundle, the paragraph beginning, BT's mistake originated from. So that's the top of page 22, supplementary bundle number 1. Unless I can insist whether those are us.
Thank you very much. Sarah. Thank you very much.